worse a functioning of the NJSC than we have with the collegium. I agree entirely with Justice Shah that this is currently a system that is unfortunately broken. If it can be revived, nothing like it. But it currently doesn't seem that way. The NJSC gave us an opportunity to go in a different direction. It might have been better, it might have been worse, but we should have given it a chance.
I mean, I'm just wondering, where this change is really going to come from. Because, I'm also wondering if the executive is, the NJSC amendment was made sort of when the government was still new at the time. And there's every chance that the government now feels that the collegium and the way it now functions is possibly a much better system for it to put its own judges than the NJSC. And that it is easier to sort of influence the appointment process through the collegium rather than through possibly a commission, which might have entailed a little greater transparency. And I know that Mr. Datar was, at the end of the NJSC judgment, there was a short ruling that was made by all the judges where they agreed to look into the collegium and try and see how to improve the workings of the collegium. And I know Mr. Datar and Ms. Pinky Anand were sort of asked to take suggestions from the public, and Mr. Datar had said that there were about 11,000 comments that had come from various different people on how to improve this collegium. So I'm wondering in whose interest, is it in any of the judges or the present collegium's interest to actually work towards improving this collegium, and where this change might actually come from ultimately?
You see, what happened was towards the end of the arguments, it was proposed that there's a memorandum of procedure, and as far as the act was concerned, by the time it was very clear that the act would definitely fall, it would not survive, and then they appointed Mrs. Pinky Anand and me as two-member committee to get suggestions from the public. And I'm so glad that all of you are here. We were supposed to get suggestions up to, say, let's say 2nd of November. So till 11:55 in the night, we got 11,000 suggestions, and I'm very happy to tell you that 90% were from non-lawyers, and some wonderful suggestions came from the public. That just shows that how much the society is concerned with the caliber of judges, the quality of judges, the appointment of judges. And then we categorized them into 5 different compartments, and this was put to the government to form a new memorandum of procedure, but our entire efforts were, I don't know what happened to our committee report, maybe just gathering dust somewhere in the ministry. But one suggestion was that, look, as far as the collegium is concerned, how do you select, say, Arghya and Suhrith as good people? So what we suggested was, let the collegium continue the High Court level, but at the Supreme Court level, let's start with this committee. One was to have a secretariat. Today, there is no formal, there's no minutes, there is no, like in a board meeting, you have board papers, you have background papers to a particular decision. So what are the background papers? So they said, let's have a secretariat, which will be doing all the administrative work, collecting the details about the candidates who are going to be appointed, and then they will have some process. Then they said, make it very clear, less than 45, we will not appoint him. Keep it a benchmark. However good you are, below 45, he will not be appointed as a judge. For Supreme Court, the age was 55. Then what are the basic qualifications? Should he have an income of more than 3 lakhs per year? So they all said that put clear criteria which are known, and then there is no need to, like today, however good you have to retire at 65. A High Court judge retired at 62. You could be the most brilliant judge, but you have to go at 65. So like that, if you have clear criteria, that was what we suggested, secretariat we suggested. And then we suggested that if you can't have an NJSC, at least have an independent committee with many retired judges who can be have a panel of 15 judges, because everybody can't devote full time. At any given point of time, 5 people can be called. Suppose it's a Tamil Nadu appointment, get somebody who was formerly in Tamil Nadu and get. That was what we suggested. Let's have, see now, unless you amend the constitution again, the collegium system will continue. We have to live with it. There is no other option. The only way we can make it work is to have a better memorandum of procedure. And I think at the heart of it, like somebody said, the constitution is not vile. It's we people who make it vile. It's the people who operate it which will make it work or not. So if at the heart of it, if your goal is to appoint good judges and all of you are committed, there will be no problem. But that's an ideal situation. It's utopia. We have to understand that every government has tried to influence the system. So we'll have to have some system which will insulate it from possible political interference by having objective criteria, some kind of an independent survey mechanism where people who are in the selection process are at least free from these kind of influences.
So just to come in on that point, I think change can only happen if there is a crisis of some kind. Because as you rightly said, I don't think it's in anybody's interest, certainly not the judiciaries or the governments now, to make any change to an existing system, because I think it's working for both. And the fact of the matter is that I think a crisis will only happen if the number of Qureshis unfortunately multiply. I think it's only when we have these instances of egregious cases, which frankly have no justification. I don't think there can be any justification for this. And it's only when these cases multiply that we may reach a tipping point, because currently I don't see any prospect of either reforms of to the collegium or certainly an NJAC 2. I frankly don't see it happening. I'm sorry to strike a dispiriting note.
Yeah, just before you start, I mean, there'll be a microphone that's passed around to anyone who wants to ask a question, and I mean, this is something that we tend to repeat often, which is that if you can just keep your comments, I mean, down to questions as opposed to making comments. Right?
My question is, President of India has got power to interfere like Crossy's case. That is only my question.
Yes, so actually the power of appointment or transfer belongs to the president in the constitution. President in the constitution means the executive. The way in which the executive function is interpreted is that the decision will be made by the Chief Justice of India and the collegium, and the executive will ordinarily say yes, unless there are reasons. Now, in cases like this, so certainly the executive does have a say in the appointment, but it should have some cogent reasons. Currently, it doesn't seem like there are cogent reasons in several cases. But one more point is that I don't always think that it's only certainly the executive, and all governments have a vested interest in the judiciary. That's the nature of the system. But I think what's very dangerous today, where we are living, is the fact that the impediments to the independence of the judiciary are not only from outside the judiciary, they are also within.
So, a quick question for Mr. Arvind Datar. You said that you had analyzed 213 countries on how they appointed their judges. Apart from India, how many other countries were there which had only judges appointing judges? That's the question for, and the younger people on the panel, you know, as users, we expect quick dispute resolution from the judicial ecosystem. Is there any other taxpayer-funded mechanism that is more efficient or inefficient than the judiciary?
Both questions are to me, or?
These are younger people, they'll outlast us.
Yeah. No, as far as the only judges, the only instance we found was the UK, where though the Lord Chancellor is part of the government, but he's the head of the judiciary, and the judges appoint themselves. Then they, of course, went into a selection procedure, we make an application which is criticized. But judges appointing judges was only in one Indian, it was the UK case. There was another one stray case from a small country which is virtually unknown, but otherwise there is no such system. So this was perhaps by means doctrine of necessity, where judges appoint themselves. But I want to repeat that the thing that judges appoint and they have the last say is not simply true. The executive does have a say, yes. And as far as the other question about which taxpayer institution is giving thing,
Less efficient.
well, I don't know. We got executive and legislature in India, so well, at least we don't go on strike and then not work like the parliament, etc. In fact, in the NJAC, there was one question.
I'm not sure the strike is the best example.
No, in the NJAC, there was one light-hearted moment where there was NJAC amendment was passed unanimously, and the only dissenting vote was late Ram Jethmalani. So then the question arose: at what point of time is Parliament unanimous? And they found historically that Parliament is always unanimous when it comes to increasing their own allowances.
Yeah, I mean, just to answer, I mean, I don't think this is necessarily a case of judges appointing themselves. I mean, we tend to say that, but there is a role even in the present system, as we've just seen. I mean, we've seen the executive, I think, playing more than a fair share of having more than its fair share in terms of how appointments are made.
I think on that second point, as in we are unfortunately in a race to the bottom with in terms of how taxpayers' money can be used in suboptimal ways. But as far as the judiciary is concerned, and I think this is a valid point and a subject of a different discussion, but I do think that we also need, while questions of appointments and so on are critically important, as in for the common man and woman, and whether it be the indigent person or it be a corporate, The fact is that the real question regarding the judiciary is one of delays. And I think
And just to answer a further point on this, it's not just the judiciary, you must take the tribunal system also.
That's right.
The other difficulty is a very, very small percentage of our GDP is spent on the judiciary. In fact, Justice A.P. Shah, myself and the law secretary, we had to give evidence before a parliamentary committee on tribunals. And it was found that in many tribunals there is no infrastructure. Now if you don't give infrastructure, how does the thing function? So if you compare to most countries, our percentage is it's just 0.3 or 0.4% of the GDP is spent on the judiciary, which is woefully inadequate for a country. In fact, in Singapore, if you see the website, the law is supposed to be the 7th source of employment. If you just have more tribunals, can you imagine the number of employment you will give? That nobody realized.
Sir, I have two questions. Senior lawyers are recommended for judge position. One of the criteria is income. With due respect, what is the logic behind fixing a income criteria? Merit alone, of course, only merited as senior lawyers are appointed. There is no second opinion. But whether is there any need for income criteria? So much of income should. Question number one. Question number two is, I understand.